US President Donald Trump and Iranian President Masoud Pezeshkian remotely signed a Memorandum of Understanding to de-escalate their conflict and open talks on reaching a final agreement. While much of the draft text and the final agreement are the same, additional details on Iran's nuclear program are still set to be discussed during the 60-day negotiation period. The deal has led to some Iranian and Gulf vessels through the Strait of Hormuz that have been stranded in the Persian Gulf since the start of the conflict. However, there remain plenty of areas for dispute, including over the schedule for sanctions relief, the mechanism for the $300 billion investment fund for Iran, and nuclear negotiations. Whilst US President Trump insisted the deal was a total victory for the US, the assertion is not backed up by anything in the agreement. The deal states the US is to move first, after which Iran will reciprocate. That is not usually how things work in cases of an unconditional surrender. The US got none of its original demands, which were an end to Iran's nuclear and ballistic missile programs, unconditional surrender of the enriched material in the country, and an end to its support for proxy groups. Just a day after the US and Iran signed the deal, Israel escalated dramatically in Lebanon, launching a renewed invasion in the south of the country and killing at least 47 people via airstrikes, with Hezbollah killing at least 4 Israeli soldiers. Whilst the US-Iran agreement appears to grant significant concessions to Tehran, it remains to be seen if it is a genuine peace effort. A United Kingdom court has handed jail sentences to 4 activists from the Palestine Action group on terror charges after they were convicted for a raid on an Israeli arms company. The judge handed down sentences of about 5 to 8 years to the quartet as he branded their August 2024 raid on the Elbit Systems site in Bristol a terrorist act. What made this case unique was the accused were arrested and charged and faced trial on criminal damages. Criminal law has usually been used to deal with protests and other forms of direct action. Such acts have been distinguished from ordinary criminality and treated more leniently than ordinary criminality. The approach of toleration, while still applying the criminal law, has been central to meeting Britain's human rights obligations to act proportionately in its treatment of the rights to freedom of expression, peaceful assembly, and association. The 4 were convicted at a retrial in May, at which they were found guilty of criminal damage stemming from an August 2024 action that successfully disrupted Israeli weapons company Elbit Systems drone factory in Bristol, destroying 40 drones in 20 minutes and, according to prosecutors, costing Elbit around £1 million. They were neither charged nor convicted of terrorism. Yet, in an abuse of judicial power, the judge invoked Section 69 of the Sentencing Act 2020 to legally brand their actions as acts of terror, adding years to their sentences and setting a new precedent for punishing political dissidents in Britain. The judge had secretly ruled on the terrorist connection enhancement during preliminary hearings, yet this decision was intentionally hidden from the jurors. The jury deliberated in total ignorance, unaware that their guilty verdict for property damage would be weaponized to classify these activists as terrorists for the rest of their lives. This verdict forms part of a broader pattern that has characterized Britain's debate on Palestine since the start of Israel's war on Gaza. Over time, criticism of Israel has become increasingly controversial. Palestine solidarity has become suspect. Allegations of anti-Semitism have increasingly been attached to opposition to Israeli policy. Now, terrorism legislation has entered the conversation. African and Caribbean countries have called for a formal apology and reparations from countries that benefited from the transatlantic slave trade. The demands come at the end of a 3-day conference in Ghana, which looked to advance the push for reparatory justice. Around 15 million African men, women, and children were captured and trafficked to the Americas to work as slaves from the 15th to the 19th century. A 19-point reparations plan has been endorsed as part of the Next Steps conference in the Ghanaian capital of Accra. It calls for comprehensive debt relief, the restitution of looted cultural property, and the establishment of a global reparations fund. It also addresses the disproportionate impact of slavery on African women and girls. The conference leaders also called on countries formerly involved in the slave trade to offer their full, formal, and unconditional apologies. It follows a landmark UN resolution earlier in March, which recognized transatlantic slavery as the gravest crime against humanity. The UN General Assembly vote saw 123 votes in favor and 3 votes, the United States, Israel, and Argentina, against declaring the transatlantic slave trade a crime against humanity. 52 countries, including the United Kingdom and European Union member states, abstained. The UK has long rejected calls to pay reparations, saying today's institutions cannot be held responsible for past wrongs. The US ambassador to the UN echoed this, saying his country did not recognize a legal right to reparations for historical wrongs that were not illegal under international law at the time they occurred. No country has ever paid reparations to the descendants of enslaved Africans or affected African, Caribbean, and Latin American nations. Most of the reparations paid by governments came in the form of compensation to slave owners in the 19th century, rather than to those who had been enslaved.